So good morning and welcome. My name is Elisa Sladinska, and I work for the City of Chicago Department of Business Affairs and Consumer Protection, BACP. Welcome to the BACP Business Education Workshop Webinar Series. We have adapted our regular business education workshops at City Hall into these webinars until further notice. On behalf of our Commissioner, Rosa Escarino, I want to inform you that business licenses can be processed online where applicable by visiting chicagobusinessdirect.org. And as I go through the information and resources, just know that I will be putting them in the chat box, so you'll be able to reference them there as well. And if you are part of the Business Start Certificate Program, you can get credit for joining this webinar by sending an email to bacpoutreach@cityofchicago.org. If you want to learn more about the program, please visit chicago.gov/businessworkshops. The City of Chicago has entered Phase 3, Cautiously Reopen, part of the city's Be Safe Chicago framework. To help guide your business and employees during Phase 3 of Chicago's reopening process, please visit chicago.gov/reopening for industry-specific guidelines. Also, BACP and the City of Chicago's Office of Emergency Management and Communications created ShyBiz Emergency Alerts. You can opt in to receive targeted emergency alerts for the business community via ShyBiz Emergency Alerts. If you are interested, please text ShyBiz, that's CHIBIZ, to 67283, or you can visit chicago.gov/ShyBizAlerts. These are alerts to businesses in targeted areas for severe weather, fire, medical emergency, or public safety disturbances that may impact your business operations. And today's webinar will be Introduction to Intellectual Property, presented by Lema Khorshid of Fuksa Khorshid law firm. And with that, I pass it over to you, Lema.
Thank you, Elisa, and thanks everyone for joining us this beautiful Friday morning. I hope you find the seminar educational and that you gain some benefit to bring back to your business after this is over. So Elisa is going to help me in facilitating the class, so we appreciate your patience and your time today. So a little bit about my background. I've been practicing law for about 16 years. I've started and sold 2 businesses, and I'm also a partner at my law firm. I try to teach the seminars in a way that they're very practical for an entrepreneur or a business owner. And if you have any questions, I welcome any of your questions. I'm going to try to do it so that I answer all the questions at the end of the seminar, just so we can address all the questions in a timely fashion, but we're also not interrupted and we can get through the material. As Elisa mentioned, this is an IP basics class, so we essentially split the class in 2 parts. This is the basic first part. So we're not going to get into a lot of the nitty-gritty of intellectual property, but we're going to provide you with a foundation whereby you'll have a good working knowledge of what intellectual property entails. Okay? So with no further ado, let's get started, Elisa. So what is intellectual property? Think of intellectual property as creations of the mind, and they include, inventions, literary or artistic works, design, names, and slogans. They're legal rights granted for these intangible creations, right? For your design, your name, your slogan, and they also help prevent Consumer confusion. They can safeguard your company's use and sale of a unique novel invention. And they can protect proprietary information and confidential business information from misuse by your current or former employees, your independent contractors, and your competitors. So, Elisa, if you could flip to the third slide, because I went a little bit fast, and I can't. The third one, the next one over. So there are several categories of intellectual property. So there's copyrights, patents, trade secrets, and trademarks. There's also something called trade dress, but we'll cover it in the next seminar. And each of these categories has a different function and provides different rights. So it's important for you to understand the distinct differences in order to fully protect your company. Lisa, if you can move this on. So the first thing we want to talk about is a copyright. So copyright essentially protects an original work fixed in a tangible medium. So think of copyrights as protecting work that is written or visual. It's a very inexpensive tool to protect those types of your company's assets. And it's, remember that the works have to be original and fixed in a tangible medium. So what that means is you can't copyright an idea, and you can't copyright, for example, a set of facts. So it has to have some originality to it. So examples of that would be a poem or a play, a film, a painting or a drawing. All of those things are protected by copyright because the creator fixes those work or places it in some tangible form, right? When I paint a picture or I draw something or I make music and I record it or I write a poem or I write a play. So it's a work and it has to be original, right? Someone else didn't create it and I'm actually fixing it to a tangible medium. So copyrights can provide protections for many aspects of your business, so as long as you have expelled some amount of creative expression. Remember, you can't copyright something else that someone else already wrote. So the owner, the copyright holder, has a bundle of rights. And those rights are the right to reproduce, the right to prepare a derivative work, the right to distribute, or the right to display something. The creator of the work is called the author, right? They authored the work. So examples of copyrights for businesses could be software code, a graphic design displayed on your premises or on the website, or any sort of instruction manuals or training manuals that you've authored. Now, you register a copyright with the Copyright Office, and the copyright, the U.S. Copyright Act, gives you some advantages. It eliminates someone saying when you register the work, I didn't know about the work, so I'm an innocent infringer or copier. And it protects your works in the instance that you decide to import those works. Registration of a copyright lasts for the life of the author, remember the creator, plus 70 years. So works made for hire, which are prepared, for example, by your employees in the context of employment, or ordered or commissioned by you. And remember, if you have your employees create any sort of copyright for you, it has to be expressly stated in writing to vest in you, the employer, so that you would have a work made for hire. So for works made for hire, the term of the copyright protection is 95 years after the publication or 120 years from creation. Now, after copyrights are patents. Elisa, if you can move forward. A patent is an exclusive right for a product or a process. So a patent excludes others from using, selling, offering, or importing the invention. Okay? A patent, to get a patent, your invention must be new. It has to be useful. It has to be non-obvious. And it can't be already in the public domain. So types of patents are usually utility or design patents. But what you want to consider as an entrepreneur or a business owner is if you innovate something, consider early on to speak to a patent attorney. And the best practice is to speak to one before you disclose it to the public. So examples of patents some things that are covered by patent protection are, like, for example, your iPhone, a drone, Bluetooth has patent protection. Then, Elisa, if you could move forward, talked about this at the beginning, is trade secret. So think of a trade secret as some set of information that you derive competitive advantage or economic value from, so that it's non-known to the general public or readily ascertainable by others. And you keep it secret, right? So that's why it's called a trade secret. As an entrepreneur, you take reasonable efforts to maintain its secrecy. So examples of trade secrets might be the formula for Coca-Cola, right? Or Google search algorithm, or a company's client list. So think about it as things in your business that give you economic value or competitive advantage, and you've taken reasonable measures to keep them secret, right? The reason you wouldn't want to file, for example, for a patent for the Coca-Cola formula or the Google search algorithm is because those companies realize that the minute you file for a patent, that information becomes public. So think of trade secrets as secrets within your company that you've kept secret, right? And that are not in the public domain, that you haven't filed a patent for. So in your employment agreements or in any agreement with your vendors or anyone that interacts with your business, if you have any sort of trade secret, it's always a good idea to have provisions in your employment agreements, for example, that identify your confidential information and your trade secret information and put your employees on notice that they should keep that information secret. Elisa, if you want to go to the next slide. Now, unlike patents or copyrights, a lot of you will be looking to get trademarks for your businesses. So trademarks are essentially customer shortcuts or identifiers of the source of the products or services. So it basically, when a customer looks at a logo or a name, they do a mental shortcut as to who the source of the goods are. So look at them as words or phrases or symbols that identify and distinguish the source of the goods. So sometimes they could be smells or sounds or colors. So think of the chimes on NBC or the color brown for UPS. Acquiring trademark rights requires you to use the mark in commerce. So what does that mean? So just because you have a name and a logo and you're not selling anything, or marketing and selling something to the general public doesn't mean you have rights in the name or logo. So you have to use the mark to get acquired trademark rights. And bought or sold. At the heart of trademarks are this consumer protection mechanism. So because trademarks identify the source of goods or services, trademarks distinguish the origin of the product, so it allows consumers to understand the aspects of the product because they come to think of the brand's expectations. So, for example, if you walk into McDonald's, you know exactly what type of experience you're going to get, right? You know how it's going to look like, you know what they're going to sell, and so essentially, although the trademarks protect the business, they also protect the consumer because they identify to the consumer who the source is, so that way the consumer, in doing the mental shortcut, knows, and understands the aspects of the products and services that they have decided to purchase. So why would you bother with a trademark? We talked about how they distinguish your brand, but they can also help inform your potential customers about what kind of product that you have and what kind of experience that you can expect. So solid brand recognition is critical if you plan to expand. So because the brand will convey, as I said, the credibility, and it builds consumer confidence in the products and services so that your consumers know where those are. Examples of trademarks are any brand name. So think about Starbucks, think about, Gucci, any sort of brand name are usually trademarks. There are slogans. So for example, just do it for Nike. And then it's the McDonald's Golden Arches, because all of those things, all of those examples of trademarks, essentially when the consumer sees them, they immediately do, like I said, that mental shortcut so that they can identify the goods and services. Lisa, if you can hit the next slide. So trademarks are important, right, on 3 levels, like we said. They distinguish the origin of the goods and services, they protect your brand and your promotion, and then they safeguard you from copycats. Lisa, if you could go to the next slide. So 3 tips for choosing a trademark. So before I go into this slide, I highly recommend that if you're thinking about a name for your business or a name for a product that you're launching, if your business is established, that you do a simple Google search. Because if you enlist the services of a trademark attorney and you're going to register or try to register a mark, you should make sure that no one else is using that mark for the same type of business that you're doing. Because if that happens, even if you fall in love with the name, you're going to have to rebrand, pick a new name. It's going to be very costly and time intensive. So best practice is do a simple Google search, get on the Secretary of State's database, and make sure that no one is doing business in your same name. And a lot of people fall in love with the name. That you do that, you're going to get a cease and desist letter from the senior trademark user to tell you to stop using the name, or they'll take legal action against you. So all practice for you to make sure that you are being diligent about the name that you choose. And if you choose a mark, here are 3 tips. So 1, you want to select a mark that's distinct. And a mark that I call is a strong mark, okay? So avoid marks that describe the product, right? Think about previous marks, like for example, Kodak for film, or Apple for computers, or Exxon for petroleum. Those don't describe the products or services. So if someone else is using the same name or a similar name, like I said, do not register the mark, okay, or try to register the mark. And then the third thing is, like I said, use a strong mark that doesn't describe the product or services. Okay, Elisa, if you can move it forward. So once you've cleared the name, I highly recommend, especially if you're expanding or you're doing business online, which is essentially the World Wide Web, that you apply for a trademark. Applying for a trademark is applying with the United States Patent and Trademark Office. It's not mandatory to get a trademark to use the name, but registration has a lot of useful benefits, right? It puts the public on notice that you're the owner of the mark. There's a legal presumption, right, after you get the mark registered, that you have ownership nationwide. Because short of that, if you don't get the national registration with the United States Patent and Trademark Office, you have what's called common law rights. So rights to use the mark in your direct geographic area. And, and once you get the registration with the United States Patent and Trademark Office, you have the exclusive right to use the mark in the goods or services that you specify. And in using the mark, you should use, after you register, is use the symbol R, that R with a circle around it. And a couple of things. Yeah, Lisa, you can go to the next one. So like we said, even after you get the registration, you can't sit on the registration. You actually have to use the mark in comments. But here's some tips on using marks, right? Never use your trademark after you get it registered, or just generally if you're using it, as for example, an adjective, as an adjective. So instead of saying I'm going to make a Xerox, you would say we use Xerox copy machines, right? It's not an adjective, right? And then, so like I said, incorrect uses of the mark could be I made a Xerox, or my nose is running, please hand me a Kleenex. While a proper use is we use Xerox copy machines, and for example, my sister loves sprinkled cupcakes. So, just a little bit of a rewind on the last thing. And then always use your trademark consistently, right? So some people get registered and go through the time and expense and forget to use the R with a circle around it. And that again puts people on notice that your mark was registered. And then, Alicia, if you could go to the next slide, we're going to talk about a little bit about some of the other things that we didn't end up talking about. So one of the things I also recommend in identifying your IP is, as soon as you start your business, clearly identify whether you have any of the categories that we discussed. So if you have any copyrights, if you have any patents, if you have any trade secrets, or you have any trademarks. So once you've identified those sorts of categories of IP, your job as an entrepreneur is to enlist the proper services to make sure that that IP is protected. Earlier in the conversation, we talked about registering copyrights with the United States Copyright Office and registering trademarks with the United States Patent and Trademark Office, and patents the same, United States Patent and Trademark Office, and trade secrets in ways that you would keep the information secret in your company. Why that's very critical is once the intellectual property is out there, you get the benefits of the statutes if you register properly, and you get the benefits of the law if you treat your intellectual property exactly like that, as a competitive advantage, as an intangible way of getting a competitive advantage against your competitors. And so essentially you would do anything and everything to safeguard it. So besides registering, everyone should have a non-disclosure agreement. So if you're talking to vendors or potential joint ventures, or you're doing business with someone, make sure that you have non-disclosure agreements that protect any sort of confidential information and that assert rights into your intellectual property. So for example, your trademarks, your trade names, if you're going trade secrets, and patents that are pending. Besides your employment agreements and your non-disclosure agreements, make sure that there's a protocol in place in your company that essentially lays out how your company protects its trade secrets or other forms of its intellectual property. So you might want to put things in you might want to password protect trade secret information. You might want to have a protocol of how to destroy that information, and you might want to train your employees on how to safeguard that information. Because if you're going to avail yourself, for example, of trade secret protection, like we mentioned earlier, you have to show that you took reasonable measures to keep that information secret. So I guess what I'm trying to say is your first step should be to identify any sort of intellectual property, any sort of things that give you competitive advantage or economic gain in your enterprise. Then the second thing would be, how do I protect it? Do I want to seek registration with the United States Patent and Trademark Office, or do I want to put a protocol in place if I have trade secrets to keep the information secret? And why that's very important, because again, remember, these are the intangible things that give you guys competitive advantage. And then if I don't register it and I don't have a protocol, do my employment agreements with my employees identify these sources of intangible competitive advantage, and how are they being addressed, right? So I have provisions in my contract that address this information. And then do I have non-disclosure agreements with vendors, business prospects, joint ventures that outline, certain protocols as to how my confidential information is treated, right? So if you're just starting your business, those are the things that I would recommend. And as you continue to grow as a business and innovate, you should always inventory, new sources of intellectual property. Now, a lot of these things, if you're working with a lawyer, are very time intensive and costly. So you want to be very judicious about the things that you are going to try to protect. And what I mean by that is take the process of filing for a trademark. Once you have an application on file, it could take 3 to 6 months to be assigned to an attorney at the United States Patent and Trademark Office. And after that application is assigned, then that attorney might issue what's called an office action that cites reasons for why the application cannot proceed to registration. meaning those are the government, the United States Patent and Trademark Office's arguments as to why they're denying registration, and that is a very time-intensive and costly process for an attorney to respond to those office actions. So for your part, you want to make sure that if this is a mark that you're going to use, that this is worth the time and effort and the expense, and not only to for example answer office actions, but just generally to file the application and to spend the time and expense. So besides inventorying your marks or your IP, the second thing that you should think about as an entrepreneur is the juice worth the squeeze, right? Am I going to get the best bang for my buck? And a lot of people run to file trademarks and slogans and logos, and they end up not using them. So this is a very prudent step for you guys. The other tip that I would give anyone that's just starting to enlist counsel in protecting intellectual property as a best practice tip is make sure that you understand the terms of enlisting a lawyer. A lot of times people don't understand that applying for trademarks or patents can be a very costly process. So I highly recommend that you understand the terms of your engagement. So make sure that lawyer gives you a engagement letter, that you read that engagement letter, and that you ask proper questions about costs and expenses moving forward. Because, like I said, it could be a very time-intensive and costly process. And as an entrepreneur, you want to be very prepared on what to expect in the future. And then, finally is before even getting started, if you're a brand new business, is you should think about doing some research in the marketplace about what your competitors and other people in the marketplace are doing in terms of innovating in your space. And so I always say try to build a solid foundation in your business, whether it's you're looking at securing intellectual property or not. So that's about doing research, and it's about having a really great business plan. There's a lot of resources in the city of Chicago right now that are available to entrepreneurs like yourself, whereby, business consultants are reading business plans and giving advice to budding entrepreneurs for free. I know the city of Chicago, besides hosting the business certificate program, has a lot of mentors and free one-on-one counseling. So make sure that you take advantage of that, because as you're building your business plan, you're essentially identifying all the various types of IP and what your secret sauce is, and then it gives you more clarity on what to do as an entrepreneur, and what you should think about, and what you should ask your attorney to engage them in terms of what things you need to protect. If you've never started a business before, in a prior step before thinking about your IP is setting up your entity. Make sure that entity is set up before you apply for your intellectual property, because you want to make sure that the business owns the intellectual property, and so you should talk to an attorney about what's the best type of business is. Best practices are, if you started or you're doing any sort of or you're innovating in any space, are no matter what, keep your ideas and your secrets secret until you get the protection that you need. So that means no bragging on social media, no telling your friends and even your family. Keep everything secret until you consult an attorney and you determine which legal parameters you're going to have in place to protect the intellectual property. and regardless of what it is. And then, you know, there are two ways to apply for a trademark, one based on a use-based application and one based on an intent to use. And we're going to go over the differences in IP class 2. This is, again, just the basic foundational class. So I guess what I'm trying to say is be very regimented on the way that you approach protecting the IP and thinking about your intellectual property when you first get started. So make sure you have a business plan in place. Make sure you've done your research and name search to make sure that no one else has the name. Identify the forms of intangible competitive advantage in your business plan. And then sit down with an attorney and inventory what things can be protected. You know, whether your slogan, your logo, your name, whether you've innovated for a new process or like a new way of doing something, whether you should get a patent. And then after you've inventoried it, think about the costs and expenses that, you know, safeguarding those rights will entail, and do a cost-benefit analysis, right? Is it worth the time and expense for you? And then finally, once you've inventoried those things and you've decided to move forward, make sure that if you move forward with an attorney, you have an engagement letter in place that sets how you're going to be billed, when you're going to be billed, and then ask the proper questions about timeline, when you can mark to be registered, and what the process is for registration. And in our IP class 2, we'll probably go over more of these timelines, but again, this is a basic course. And then after you've done that, you know, you're ready to move forward with selecting your intellectual property and trying to get the right things in place for registration. And then think about your contracts and your agreements, right? We talked about non-disclosure agreements and why they're important, because they basically assert rights to your confidential information, and they create legal obligation for the recipient of your confidential information, right, to keep it secret. And then your employment agreements, right? If someone's working with you and they're intimately exposed to some of your trade secrets and your client list and your confidential information, are your employment agreements addressing those issues that occur in the work context? And again, our IP class 2 will delve into some of these things a little bit more. This was just an IP basic class. And then, you know, finally is be prepared, right? Preparedness is the name of the game, especially in entrepreneurship. So take the time and effort to use the resources that are available to you through the city to draft a well thought out business plan before you embark on any sort of business. So that's it. And I want to open up the class for any sort of questions.
Thank you so much, Leva, for going over all that information. We do have a couple questions, and I do want to encourage people to use the chat box to ask questions related to IP. So first question we have is, does it matter where you place the trademark?
I don't understand the question. If you mean where you put the R with the circle around it?
That could be, yes.
Okay, so you should put it right next to the name that you've trademarked. And you know, if you're unsure, is like just go to the grocery store and pick up a box of, for example, cereal, and you'll see the General Mills trademark, and it'll have, for example, the R with a circle around it, or Nabisco, or any of those things, so you can get a very easy idea of how that should be displayed.
Perfect. And that actually was, the person did further explain, saying, yes, where you put the symbol in the logo.
Yeah, so for the logo, right next to it.
Mm-hmm.
The same thing with the name, right next to it.
Perfect. All right, next question. While it may be easier to search for trademark work or names, is there an easier way to search for symbols?
Most trademark attorneys, and this is part of our class too, but I'll go over it, is do what is called a trademark search report. They outsource that service through a third party. You could search for designs and logos, on the BACP website, but unless you know how to really work the system and you know what you're looking for, it's very difficult. So when you enlist the services of an attorney, usually they use a third-party search service to perform what's called a certified search for a design mark, and that comes up with any potential logos or designs that could cause what's called the likelihood of consumer confusion, and that attorney analyzes it. And this will be part of our IP class too, but I'd say for logos, for all trademarks, you should enlist an attorney's services, because if you don't do it right, the USPTO will reject it, or you're going to get compensation. Yeah.
Someone asked, what is the difference between TM and the circled C, or R, I'm sorry.
Okay, so a TM, a small TM, indicates that the person using the mark is using it in their direct geographic area. It's not registered with the United States Patent and Trademark Office, and the person is asserting what's called common law rights to it. The R with a circle around it is the mark has been registered with the United States Patent and Trademark Office, hence the R, registration, right? So the TM, common law, the person could be seeking registration, but they're asserting rights in their direct geographic area. And then the R, they've gained registration with the United States Patent and Trademark Office. So they are claiming exclusive national rights.
Got it. Next question. Could you repeat what it means to enlist a lawyer?
Okay, so before you get started on any sort of legal matters, whether it's intellectual property or whether it's just general legal matters, you're going to have to hire a lawyer, right? Enlist their services. And so essentially, a lot of people don't understand how to work with a lawyer, nor do they understand how a lawyer bills. So one of the things that every good lawyer has to do is give you what's called an engagement letter. An engagement letter is a contract, an agreement between you and the lawyer as to how they're going to bill, what you're going to get billed for, what the terms of the engagement are, what the scope of the services are. Will they be filing your name? Will they be filing the name and the logo? So my tip to you is, number one, ask for the letter, but most lawyers will give you one. And two is read it. Read it and really understand what the expectations are for you, the client, and what the expectations of the lawyer are. And once you have a good handle and understanding of what that is, ask questions, right? How much will expenses be? What am I looking for in terms of fees? What's the timeline on this? Because short of that, you're going to get a bill that you either can't pay, or your expectations are going to, not come to fruition because you thought you were doing something or getting something for the cost of something else, or for the lawyer to do not what you thought you were getting. And I always teach this in the basics class for just general businesses is, in hiring a lawyer too, make sure that you really take the representation seriously. Lazy clients have huge bills. So what I mean by that is they don't put the time and effort to capitalize on their relationship in a way that is helpful to them. They'll be in their car driving and they're going to want to have a conference call. Or they'll be in the grocery store or picking up their kids or doing 3 other things while they're talking to their lawyer. And so from that standpoint, in hiring or enlisting a lawyer's services, it's not only about reading their engagement letter, but it's also being very proactive in your representation and really asking good questions and wanting, wanting to get the most out of the information. Because once you have a great relationship with your lawyer and you really understand what services they provide, it's very, very powerful for you as an entrepreneur.
Thank you. A couple people are asking, does BACP offer pro bono or a list of attorney trademark services? I'm going to briefly touch on, and Lema, if you want to add anything, but BACP, we offer typically a solution station at City Hall where we partner with the Chicago Lawyers Committee for Civil Rights, and it's the Community Law Project. Obviously, right now we are not doing in-person, or they're not doing in-person consultations, but they do offer remote services where it is pro bono. The scope of work I'm not too familiar with, but you are able to ask a little bit of organizational questions. Lema, do you have anything to add on that?
Yeah, so I mean, this area of the law is very specialized. So to really get someone that understands how to do it, any free resources that are available to you, I would avail myself of. But don't be surprised if, for example, you go to some of the pro bono services and a lot of those lawyers don't know or won't help with applying for a patent or a trademark because, like I said, it's a very specialized service. The other thing is, a lot of times is you have to run trademark search reports to determine whether or not the name is available or there's a likelihood of consumer confusion, and those are expensive third-party costs that pro bono services are not going to run for you.
Absolutely. This is not an area where you want to cut corners. It will be costly at the end, so make sure you have the right team in place. Another question came in, can I protect the handouts in my presentations? If so, how?
The handouts in your presentation. So if you're revealing any sort of like training or training manuals or things of that nature, or like some sort of training, you should try to look at copyright protection and seek copyright protection for if it's original, right? You're not just giving facts. And it's a methodology that you employ. So I would talk to an attorney about looking, to seek copyright protection. You have a copyright once you fix it into a tangible medium, which means you actually write it, put it in the handout, and distribute it to someone. The only reason you would want to get copyright protection is if someone infringes on your copyright, then the statute gives you benefits, right? It gives you statutory damages and your attorney's fees if you go to enforce your copyright. And this is we'll delve into this in class 2, but that's really what you want to think about. You want to think about it from the standpoint of do I need copyright protection on it? And if you need copyright protection on it, you should get copyright protection. And copyrights are not as expensive as trademarks or patents. So I would definitely seek a legal counsel on that.
Great. Another question. Do you have to safeguard individual pieces of work if I'm an artist?
Yeah, you should, or you could do a compilation. Again, that's a very fact-intensive question. But yeah, you could do a compilation, but more likely than not, yes. It just depends. I would need to know more facts, and that person can email me afterwards.
Yes, and if anyone does have more questions, please be putting them in the chat box. We are working.
I can't see for some reason.
Oh, no worries. Another question is, if an attorney reviews your invention and finds that there is a similar invention, but the patent for that invention is abandoned. Should you continue to pursue a patent, or since there was a previous invention, it is no longer eligible for a patent?
So if it's already got patent protection and you're trying to get the same patent, the answer is no. And if someone has patent protection on something and you're trying to get the same patent, then you're an intentional infringer, and I would highly recommend going in a different direction. Because you're infringing on their patent and you know they have a patent.
Another question, where should I start for poems and a book of poems?
That I don't understand the question, but if you're saying you want to do a compilation, you can get it copyrighted, and you're going to do a series that are linked together. But I would, unless you're going to be publishing them piecemeal, in which case you could seek copyright protection and then on each poem.
The person had a
follow-up. Apart.
The person had a follow-up of, do I register them individually or the entire book?
Yeah, you should register the entire book if it's a book of poems.
Another question, what if we have a quote-unquote system, something that is more intangible? Employees and clients should not be using our system or posting it on social media without permission.
Okay, so I don't know what that question really means, but I'm going to try to think of what I think you're trying to ask. And if I'm not, they
have a little bit additional information. It says, example, we have a client who learned our entire system and then started posting on social media without mentioning our name, etc.
So number one is, what was the agreement between you and the client? Do you have any sort of agreement that protects that confidential information? And did you go through great lengths to protect that information and assert rights to it? And if the answer is yes, we had an agreement, yes, I protected it, and yes, it qualifies for some trade secret protection, or I got a copyright on it, or some IP, and then they went ahead and distributed essentially or published it to someone else, then you might have legal recourse. In the future, to avoid those situations, like I said, you want to look at agreements between you and your clients and you and your employees, and you want to assert rights to the IP, whatever it is, in whatever fashion it comes for, and then the consequences of them infringing on the IP. If it's your client, and then if it's your employee, what steps are necessary in handling and safeguarding the IP, right? So it all goes back to rewind. What did you do to assert rights to it? Were the rights that you asserted proper rights, right? Are they covered by intellectual property protection? And then what legal recourse do you have? So that would be more of a fact-intensive question, and then you'd know, what you can do moving forward.
If you don't mind, I'm going to share your email address in the chat box, and I'm just confirming it is lemma@sklawfirm.com.
Yeah.
Okay. I'm going to type that in for everyone. And just so everyone knows, this presentation is being recorded and will be made available on our YouTube channel. If you need to reference any of the information, you could find it at youtube.com/Chicago BACP. And I did also post that in the chat box. I'm going to give a couple more minutes, and if anyone else has a question to ask, now is your time. While we wait for any additional questions, Lema, do you have any final words or final advice, I should say, that you want to share?
Okay, so, as you embark on the journey, just like I said, write a business plan and put together a budget. And I think, now I could see the chat box, so I see some of your comments. In starting a business, you have to have the proper resources enabled to move the business forward. So there are things that are going to be very important to spend money on, and having good legal counsel and sound advice is critical for the success of your business. But that's not to say that you have to spend a lot of money on lawyers. Like Elisa mentioned, the City of Chicago does have the Community Law Project, so I would definitely start out by talking to a lawyer at the Community Law Project to see if they can help you with your needs. And if they can't, then you have to think about it as an entrepreneur, and you have to build in your budget the cost of making sure that all your hard work and your time is actually being protected. So that would be my advice to you.
Perfect, thank you. And
thank you very much, Elisa, and thank you for everyone for joining us this morning.
Absolutely, thank you again. This was super informative. Once again, I did put Lema's contact information in the chat box, as well as information where you could find this presentation and reference it later. And with that, I just want to say thank you again, and I hope everyone has a very enjoyable Friday and weekend. Thank you.
Okay, thank you. Bye.